Hello everybody. Today we're here on our channel and we're going to talk to you about the green card and what it means to get the green card. Let's just pull this over so you can hear me. And I want to talk to you a little bit about that, okay? So how do we get the green card? What's the best way to get the green card? There's so many different scenarios, and we want to make sure that you understand the different scenarios in order to get the green card. So the first question I got this question. It says, "Hi, I'm married to a U.S. citizen. Can I apply for a green card in the United States?" So here's how it goes. If you enter the United States legally and you're married to a U.S. citizen, always you can do your residence within the United States. If you have a child, okay, and you're married to a U.S. citizen and that child is below 21, your spouse can petition for the child and the child can get their residence within the United States. If they're older than 21, they'll probably have to do the residence outside of the United States, depending. That also depends because if you got married before that child was 18 years old, chances are the law is your spouse will not be able to petition for that child. But if you got married to your spouse and that child was below 18 years of age, then your spouse will be able to petition for that stepchild. So remember the differences, okay? I know it's a little complicated, but try to remember the differences. Okay, the other question I have is, I entered the United States illegally, but now I'm married to a U.S. citizen. Can I still get my green card? Yes, you can. Now, here's the difference. If you enter the country illegally and you're married to a U.S. citizen, you need to do a waiver. So that waiver is called a 601A waiver. And when that waiver is approved, then that's when you can apply for your residence with the American Embassy in your country. Now, if you have an order of deportation, remember that you need to do the I-212 waiver first. Then when that's approved, you do the 601A waiver second, and then you apply with NVC, the National Visa Center, for your residence to do your residence outside of the country. So yes, you can still get your residence if you enter the country illegally, but remember, one thing that you need to remember is that you need to apply for those waivers or at least one waiver if you don't have an order of deportation before you leave the United States. Because if you leave and you do all the paperwork to get your residence, to get an appointment with the American Embassy, and you don't have your waiver, you won't be able to come back in the country. They'll let you do another waiver, and that waiver could take 2 or 3 years. So be careful. Before you leave the country, remember to check with an attorney first. Make sure you do the waiver first. Okay, the next question. I have a deportation order. Can I apply for my green card through my spouse? So if you have a deportation order, you can still apply for your residence with your spouse, but there are a couple of things that you need to do. If you're going to do an adjustment of status in the United States, let's say you enter the country legally and you're married to a U.S. citizen and you have an order of deportation, can you apply? Can you still apply within the United States? Yes, you can, but you must remove the order of deportation with the immigration court. So now you need to do what they call a joint motion to reopen, send that to the trial attorney, the prosecutor of the Department of Justice. Once they approve it, then you file it with the immigration judge. And once the judge signs it, then that's the way you remove the order of deportation. Once you remove the order of deportation, then you can file your adjustment of status, the I-130, I-485 adjustment of status application with the USCIS. Now, if you file your applications before you remove the order of deportation, sometimes immigration will deny the case and say, well, you have an order of deportation. We're not going to give you your residence. Sometimes they'll say, okay, we'll close the case and we'll give you a chance to go before the immigration judge and remove the order. Now, we've done it both ways and we've succeeded, but under this administration, I'm going to advise you not to apply for your residence before you remove the order of deportation. Under this administration, I am going to tell you, please, to try to remove the order of deportation first. File the I-130, remove the order of deportation, then file the application for adjustment of status. Because if you do it the other way around, you could get detained when you go to your interview. Okay, so that's important. All right, the next question. My green card expired. Does that mean I'm no longer permanent resident? That's just such a good question because a lot of people panic. They come to the office and they're panicking. They say, "Oh my God, my green card expired. That means I'm not a resident." No, you're still a resident. Your residence did not expire. What expired was your card, the card itself. Remember now that immigration gives a card for 10 years. So before the expiration of the 10 years or before the 10 years are up, you need to renew the green card. Now, what we do is that we tell our clients that after 5 years, why don't you just apply for the citizenship? And then you don't need to worry about the green card. But a lot of times some people say, well, I don't want to apply for my citizenship. Or sometimes people will say, I don't speak English well enough, or I'm afraid of the exam, or I can't study the exam. I don't want to do my citizenship. Okay, that's fine. You can still remain a resident forever. But the most important thing that you must remember is that please remember to file the your I-90 form to renew the green card before the expiration of the 10 years. This is very important. Don't travel. That's the next thing I want to tell you. Don't travel if your card has expired or is about to expire. Make sure to renew your green card before you travel. Okay, so that's important. That's an important tip to remember. You're still a resident, but if you decide to travel and your card has expired or is about to expire, the immigration officer could tell you not to come in or could put you in deportation proceedings. So be very careful with that. Okay, next question I see here. Um, I got my green card through marriage, but it's only good for 2 years. What do I need to do next? Okay, so if you get your resident card through marriage and you've been married less than 2 years, immigration is going to give you the card for only 2 years. Okay? So before the expiration of 2 years, like let's say about 30 to 40 um, days, or let's say 2 months or 3 months before the expiration of your card, you need to file what's called as I-751, and that application removes the condition of your permanent residence. It removes the condition of the 2-year resident card. And then after you file the I-751, immigration will issue you an extension of your residence, and then you will get the card in the mail for 10 years. Now, some people tell me, well, I got this extension for 4 years. Yes, that's normal. Another person said, well, you know what? They sent me after a year, they've sent me an appointment to do my fingerprints. Is that normal? Yes, that's normal now. With this administration, you have to do fingerprinting a few times. And some people say, well, it's been 3 years. I've been a resident for 3 years. I'm waiting for my permanent card, my 10-year card, and I can now apply for my citizenship. Can I apply for my citizenship? Yes, you can. You can apply for your citizenship if you've been a resident for 3 years and you've been married for 3 years and you're waiting for the approval of your I-751, which is the application to remove the conditions of your 2-year card. So yes, you can go ahead and you can apply for your citizenship, but be careful. Speak to an attorney before you do it, okay? And you know what? Subscribe to our channel because we come here every week and we're giving valuable information about immigration. Subscribe to our channel. Send us a question if you have a question, and we will help you. Okay. The other question I have, can immigration deny my green card if my spouse and I live in different states? So I am going to imagine that with this person, this question is you got married, but for whatever reason, you live in one state and your citizen spouse lives in another state. Yes, immigration can deny the residence for that reason. You're going to have to show really, really hard that it's a valid marriage because supposedly if you're married, you're supposed to live together. And that's the way immigration sees it. That's the way they look at it. That's the way they want it. So if you're living in one state and your spouse is living in another state, maybe it's for job reasons, financial reasons, that you have a good job in one state and your spouse has a good job in another state and you're not able to get jobs in the state that each of you are living in. So that's valid, but then be prepared to show that you call each other every day, you visit each other, you see each other, you have WhatsApp, you talk by WhatsApp, you talk by text, and that you're really, really in touch, that you're putting a lot of stuff in your names together, you have a bank account together, you're filing your taxes together. So be prepared to show a lot of documentation. I don't recommend it if you're married And if you're going to apply for your residence through the marriage, you need to live together in the same state, in the same house. Okay, just remember that. Okay, the next question. I applied for adjustment of status, but I need to travel for an emergency. Can I leave the United States? Well, if it's an emergency and you can document the emergency, yes, you can travel. I don't recommend it. Again, that's something I don't recommend unless it's a really emergency. But remember that you need to apply for a travel permit before you leave the United States. If when you applied for your green card, when you were applying for the adjustment of status, you did not file Form I-131, then you need to do it now. You need to do it now before you leave the United States. Call USCIS, try to get an appointment. They'll tell you to bring the Form I-131 with 2 photos of the money order. Make sure it's a real emergency. If it's not an emergency, immigration will not give it to you. I had a situation recently where I had someone from one of the African countries that that there are 75 countries now that are on hold. So the USCIS is not processing applications from those countries, or if they do process the applications, they're not granting them right away. Or if they do grant them, they're not telling the person, okay, here's your residence. The person has to wait. So if you're in that situation, remember that even if you get that travel permit, you might not be able to enter the country if you are one of those countries within the 75 on that list. So be very careful with that. Speak to an attorney before you leave the country, before you decide to leave. But if it's a real emergency, the death of someone or someone is dying, try to make an appointment with USCIS before you leave. Okay, that's important. Okay, then the other question is, I have a pending asylum case. Can I still apply for a green card through marriage? Yes, you can. Yes, you can. Now, if the asylum case is pending with USCIS, I recommend that you withdraw that asylum case after your interview with the USCIS officer. Because at that point, you will know if the USCIS officer is going to grant the case or not. You'll have an indication at least. So if you're in that situation, go through with your residence first, okay? Go through the interview, try to get an indication if if you're going to win, or wait until you get the approval in the mail, then withdraw the asylum application. Why am I saying this? Well, just suppose the officer takes a long time in granting your residence and you withdraw your asylum application. You're going to be without a work permit. You're going to be without a license, a driver's license, and that's not a good place to be. So I always recommend to my clients, wait until you get an approval of your residence, and then withdraw the application for asylum. Now, if you're in court proceedings and you have an asylum application pending with the court, same thing. What you could do, you could file the I-130 application. When that's approved, withdraw the asylum application, ask the judge to terminate proceedings. Now, there's a difference between termination of proceedings and AC, administratively closing proceedings. Make sure that the judge terminates the proceedings. And if you get something in the mail that says that the judge administratively closed your case, go back to the court and ask the judge to terminate proceedings, because with an order closing proceedings, the USCIS officer cannot grant you your residence. So you need to get an order from the judge terminating proceedings. So this is very important. Now, the second thing I want to tell you is there are some people that have said, well, I'm going to file my entire application with the USCIS, and then I will ask the judge to terminate proceedings. It could work, but the safest method is do the I-130, ask the judge to terminate proceedings, show the judge that you're eligible for adjustment of status because you came into the country legally, and then file the I-485 application. All of this is important. The steps that you take are important. The strategy that you use is important, because you don't want to be in a situation where you're facing deportation, you get picked up, you get detained, and then you have to fight with the immigration court or fight ICE to get out. Okay, so try to make the steps, do the steps in the way I'm telling you. Okay, what happens if my green card interview does not go well? Well, you can appeal. You can appeal. A lot of times the interview doesn't go well because people forget. That doesn't mean that you don't have a valid marriage. Sometimes people forget, they'll forget things like, What color is your wife's toothbrush? What color is your husband's toothbrush? A lot of times people don't pay attention to that, so they don't remember. Or when was your first date? Somebody may say, "Well, my first date was in January." The other person said, "Well, my our first date was in February." Or somebody will say it was around Christmas time. The other person will say it was around Thanksgiving time. So you have to make sure you practice before you go to the interview, so you have the same answers. If it doesn't go well, and you have to define what it means, if the officer could say, "Well, you guys had different answers." Usually, what the officer will do is will send you a letter, and it's called a request for evidence, and they will request additional evidence. They'll say, your answers were not correct, but we want more evidence to show that your marriage is valid. If that happens, that's a good thing. You can submit more evidence. You can submit an affidavit from people that know you, his parents, his family, her parents, her family, affidavits from family members, more pictures, affidavits from friends showing that it's a valid marriage. Request another interview, request another interview to so that the office can talk to both of you together. And try to explain the discrepancies in the questions. I did that one time for our clients, and they did well. One person said, we went to Miami Beach for our first date, and the other person said, we were watching boats, the ships go by on our first date. Well, it was the same place. It's just that they said different, different kind of different locations. It was the same place, but they put different names on it. And then I had another case where the person said, well, we went to the Cheesecake Factory for our first date, but one person said we went to the Cheesecake Factory in Dadeland. The other person said we went to the Cheesecake Factory in Doral. It's the same restaurant. They just kind of forgot the location. So if you get a request for evidence in the mail, you can definitely explain those discrepancies to the officer. Okay, now the question says here, another person says, well, what happens if it's a denial because our questions were different? Still, go ahead and appeal it and explain the differences and give a lot of evidence to show that your marriage is valid. Show that you're living together, show that you have neighbors, show pictures, show that you go out together, show text messages, show WhatsApp messages, show that you talk to his parents by WhatsApp, or you communicate with his parents by WhatsApp and they live in another country. Show that you talk to her parents, so that, something, show that you've done trips together. You've gone to Disney together. You've gone to Boston together. You went to different places together. You went to parties together. You show evidence and fight it. If you have a valid marriage, you need to fight it. Don't accept what the officer says. Just because the officer thinks that your marriage is not valid, that doesn't mean that your marriage is not, okay? So you need to fight it. You need to appeal it. If there's a request for evidence, supply the evidence. And I'm talking about evidence this big, of paperwork and so on. Or if there's an appeal, same thing, fight it. Send a lot of evidence, show that your marriage is valid, and you got to fight for that. Okay, so remember now that the officers are trained to ask questions. They're trained to look for fraud. They're trained to look to see if your marriage is valid or not. So that's their orientation, and that's how they're trained. So, but you have to prove them wrong, and you can do so if your marriage is valid. Okay. The other one says, I entered with a green card with a tourist visa and I'm married to a US citizen. Well, of course you can apply for your residence if you entered with a tourist visa. Remember one thing, you need to wait 90 days before you apply for your residence. Now, one of the things that the officer is going to ask you, she said, okay, well, when you came to the United States, you came with a tourist visa, and supposedly a tourist visa is to visit the United States. Did you plan to get married, or is that because that's considered fraud? If you say, well, I came in with the intention to marry, that's fraud. If you said, um, when I applied for my tourist visa with the American Embassy in my country, I didn't tell him I had a boyfriend or a girlfriend, and I had every intention to get married, that's also fraud. So be careful how you phrase the questions. If you say, well, I just met this person, and I'm deciding to get married, well, the officer could say, well, how can you marry somebody after 90 days? That doesn't make sense. Or, but you could say something like, or it could be a situation where you've known the person for a long time. And then, when you came to the United States, it developed from friendship to more to romance, and then you decided to get married. or you've known this person for a long time and you weren't planning to get married and then you decide to get married. So be very careful with that, because under this administration, they're very strict with that. Okay, so these are some questions that I received about marriage and green card marriage and how marriage is performed, how marriage is done, the process of marriage. So if you have any more questions, let us know. And if you have, subscribe to our channel, send us the questions, um, go to the link and you can, contact us through the link, and then we'll be happy to answer any questions that you have in the future. Or if you're scared or if you need something, we are here to help you. God bless you all, and thank you.